Welcome to the European Champions Alliance event on labor law. I'm very excited to announce this beautiful opportunity to look at different perspectives and what the workforce has to face navigating between all these different European countries. Europe taken together, as we know, has an amazing talent pool, excellent infrastructure, and one of the largest free markets in the world. And paired with harmonized competition policy and robust IP protection, it also makes Europe a worldwide innovation powerhouse. But all that is not worth much if we're not able to really freely move the talent from one country to another. And this is absolutely crucial in order to create more European champions. So I'm very happy today that we are going to look at how can that European narrative actually be broken down into the national realities. What do entrepreneurs face if they work in different countries in the pan-European ecosystem? This is absolutely crucial for European tech to be more successful and to create more champions. And so I would like to now hand over the floor to Martin Riedel, who will moderate this session. It's very interesting to look at the legal specificities of what is necessary to move people and to hire people in different countries in Europe. Martin, the floor is yours.
Thank you very much, Jean-Christophe. And good evening to all our spectators who have taken the time to attend such an interesting topic as how to get your boots on the ground, how to hire in Europe. And Jean-Christophe, I'm not sure that you have already realized that because you're not so much into football like some of the other participants. But when we have chosen the countries to participate in that webinar like 6 weeks ago, we perfectly have chosen only countries who would make it to the last 16. I would say that is just amazing. So I would like to present you shortly the panelists of today who will be able to give you background information of all the legal points and best practices and good advices that you should follow if you want to hire in these countries. I would like to start with Ludo. Hartelijk willkommen. Ludo from Belgium, from our partner in Pagianet in Belgium.
Hello, from Belgium.
Ludo, is Belgium going to win the European Championship?
Of course, who doubts it?
Okay, so we asked the question to José from Barcelona in Spain as well. What about Spain? Who's the favorite?
Good afternoon. We began in a very badly way and we can only go up. Thank you.
Karoline from Austria, Pagianet, is of course the underdog, and I'm sure you're still thinking at least you're going to make it to the finals, right? Karoline, I think your microphone is not on. Could you check that? Yeah, try again.
Can you hear me now?
Ah, perfectly.
Yes.
Perfectly.
Okay. Hello from Austria, Vienna. Hi. Yeah, we're just happy we made it to the knockout round. So let's go from there.
Okay. Switzerland. Roy, I love the symbol that you have chosen for Switzerland. That is so emblematic, I would say. Where's Switzerland going to end up in that Euro Cup?
Hi everyone. Well, if I knew that, I would make a lot of money probably in the next week. But we are happy, like Austria, we're happy to be in the knockout stage, and anything on top is just fantastic.
Okay, Uwe, I think I will have to disclose directly your well-kept secret, because although you are from the Pagianet partner in France, you're German, at least when it comes to football. So what about the British?
Like you said, it will be a good match, and then there will be penalties, and Germany will win at the end, like always. Like Karoline said.
Reinier from the Netherlands of Pangea.net. What is your idea? Are the Dutch going to play the Germans or the English? And sorry that I said British. That is, of course, Raymond. Very sorry.
Well, actually, I am not able to tell you that, but I do know that the Dutch team heavily depends on its supporters. So the Orange team has a vivid group of supporters, and I think they need us this year.
Okay.
We survived.
Raymond, I know your answer. This time you practiced penalties for so much time that you're going to beat the Germans, right?
Yeah, absolutely. We have to believe that. I think the only thing I know for certain is that it's going to be emotional in this country, and I hope it's not going to be tearful emotional, but I fear it might be. But who knows? We've started slowly, but we won our group. We just need to score more goals, but Germany is always the big game. So yeah, and I can see penalties and I can see tears. But anyway, yeah.
Okay, so my last guest is Benjamin from Germany. And since Uwe already made a speech about the German chances, what about France? Where are they going to end up?
Well, they played us quite well, so I have to say they are heavy favorites for the title. Let's see when and if we meet again.
Perfect. Now that we have given answers to all the important questions, we can go to the show where it's a lot easier to answer the question because it's only about legal stuff. Our idea is to talk 60 minutes about questions that were sent to us by the public and questions that we felt in our day-to-day practice are interesting for companies, especially scale-ups who want to go abroad. And after that 60 minutes session, we still have 30 minutes where we give the spectators the possibility to answer questions or to ask some of our panelists to go deeper into some of the issues, because since we are 8 different jurisdictions, and that is amazing to have such an expert panel in just one webinar, we have a complete new method of answering the question, and we're gonna try that out directly. Who can hear me? Please show the sign. Perfect. I hope that you all of our spectators can see that because I'm going to ask questions. And so we tried to draft the questions in a way that we can easily sort out the jurisdictions where there's no problem at all for doing something, or we can see at least which countries are using the same standards, having the same approach to a problem. So that we can easily identify these exotics. I have a small suspicion that France might be quite often mentioned in this way, but that makes it easier for the spectators to follow our discussion, because I understand that legal issues, especially when it involves a different jurisdiction, it's not always easy to follow, but we will try to give our best to guide you through that jungle. And you will see in the end, it's not so different. We come to similar solutions. It's only sometimes we come from different sides, but that should not be surprising if there are some people who drive on the other side of the road, which is quite more dangerous. So we're going to start with our first question, and that is a question that I often hear from my new clients, and that is, do I need a local company in order to hire an employee in that country? So the answer is easy. It's no. You don't have to establish first a company before you can hire someone. So don't go into these extra efforts, unless, of course, you have other arguments to do so. And that is something we might talk about in another webinar, because we were going to make several webinars, and one of them will be about tax law. And when it comes to tax law, it can make sense to establish a company right away, because for accounting purposes it might be easier. But when it comes to labor law, nevertheless, some candidates will tell you that you should open a company first, that should hire them. That is not necessary. If you're a French company, you can hire an employee in Germany directly, in Spain, in UK or Switzerland, or all the other countries represented here. So sometimes there's an easy answer to a difficult question, and that is, you don't need a company. Our second question is, do I need to register my employees? There again, Raymond, I think you're the only one who shows a no. Raymond, do you know why you don't have to register? Well, you don't even have identity cards, right?
We don't even have identity cards. That's right. No, exactly. Land of the free. So yeah, no need to register. So we are different to most of you or all of you on that front. Absolutely right. Yeah.
Okay. If I go to Belgium, for example, Ludo, what does it mean to register an employee?
Well, in the first place, it's very important to know that before you employ someone here in Belgium, he has to be registered with our national security, social security office through an online tool that you have on the internet. You could be fined very heavily if you start employing someone who is not registered right at that moment. So upfront, you have to register the employee before you start working with them.
So it's very important to do that, but that is not rocket science. And if you ask your lawyer, he can help you, of course, to do that, or find a service provider who does it for you. Perfect. My third question is, does my employee need a work permit? Well, for the first time, we have some differences. So I can see in most countries, there is a need for a work permit. Uwe, I think you showed that in France, this is the case. What does it mean, a work permit? Is that difficult to obtain? Does that apply to European citizens?
Of course, for European citizens, it's easy because you are exempt from the obligation. But normally, it's not easy to obtain. It's quite often immigration and work permit are related. So you need to get a visa which permits you to work in France, if you are not from the EU, of course.
So if I put the question in another way, because I think mostly the clients that I have, if they want to go into a new market, they will hire somebody who knows this market. So is quite often either a national of that country or has been living and working in that country for quite a long time. So the same question, if I want to hire somebody in your country and that person has been living and working there for several years, do I need to care about a work permit? Or
if he's not a national from the EU, sorry, then still you have to, as an employer, you have to make sure that he has the work permit, and you have to make sure that it's always valid. So if normally it's given for several years, but when the deadline comes up, you have to make sure that he is getting a new work permit.
Okay, but that means the other way around. If it's a EU national, then I don't have a headache with work permits.
No. The problem we face right now is that for lots of our clients from the UK, they have the problems they cannot simply send people to France to even if they have a contract and they will work with their own workforce, they cannot send them over to France because they need to have this work permit.
That is very interesting, and maybe a point we can discuss a little bit further in our second part in the 30 minutes, because there might be some people interested in the consequences of the Brexit when it comes to labor law. My next question would be, does the employment contract need to be in writing in your country? Wow, only 2 countries. And this time in UK, it has to be in writing, and well, Germany is not surprising. You do nothing else but writing. Okay, so legally, it doesn't have to be in writing, but if you counsel the company, would you recommend to make it in writing? Yes, so we have 100% yes answer, which means that quite often, even though there might be no obligation and your candidate tells you that it doesn't have to be in writing, just have an exchange of emails, it's enough, or just pay him some salary to make him your employee, you should, of course, always have a written employee contract with your employee, because otherwise you will face lots of advantages, because the law normally favors or always favors the employee. So you have a great interest to have a signed contract, a written contract, and that this contract should be reviewed by a lawyer before you sign it. Does this contract have to be in the language of your country, or could it be in a like international language as English, for example? So in Spain, in Belgium, in France, of course not in UK, it has to be in the language of the country. In other countries, we are more liberal. Ludo, when I come back to you again, when we did the preview, you told me that it can be even more complicated in Belgium because you do not have one official language, but 3?
Indeed, we have 3 official languages, which are Dutch, German, and French. And in the Dutch-speaking part of the country, the northern part of the country, let's say, your contract has to be in Dutch to be valid. You can make a translation into English or whatever language, but your original contract, and not only the contract, but all relations with employees have to be in Dutch. In the French-speaking part of the country, it has to be in French. If you would have in the Flemish part of the country, for instance, a contract that's only in English, it would be void normally. So it's very important to put it in Dutch.
Okay. In each of the countries, are there any clauses that are mandatory that I, as an employer, have to agree to? Well, it's not a surprise that we have so many yes, but what about the no's? In Switzerland, right, does it mean I can do whatever I want?
No, I didn't say that, but there is no, obligation that forces you to agree to a certain clause, and otherwise the entire employment agreement would be null and void.
Okay, so there are no magic words that I need to have in my contract, otherwise it doesn't work. It's not legally binding. But so if we have a yes from Raymond, what are the clauses that you need to have in your contract unless you take the risk that your contract is null and void?
So in the UK, the laws changed quite recently to say that you have to provide the contract before the employment actually begins. It used to be that the contract sort of caught up with the relationship, but now it's been flipped around the other way. And that the contract has to contain certain particulars of the employment. So the very basic terms have to be in there, in things like pay, holiday, benefits, all the benefits that could come through, hours of work, days of work, things like that. So it's become more regulated, and more information has to be given to new employees. People that were already employed by you can be on the same terms as they were before, but new starters have to have these new improved versions of the employment contract, and they have to have it before they've started with you. Otherwise, you're in breach at the very start of this relationship.
So you're telling me that you left Brexit, you left the Europe because it was so bureaucratic, and now you're getting more and more strict when it comes to laws. It's a little bit of a surprise.
Yeah, I think it's a bit surprising. Yeah, I think it's difficult to explain, Martin. What can I say? Brexit is full of surprises, most of them unpleasant ones, and not actually surprises, actually. Yeah.
Well, my next question is one with which you cannot answer by yes and no, but maybe with your hands you can show a number of months, because we're talking about the trial period. And in case that it is possible to have a trial period in your jurisdiction, could you say how many months? And I would be happy to see if somebody has more than 10 months to offer. Can you give, or can an employee accept legally as a trial period? I see 6 from Germany. That is not a lot. 6 in Spain too. Only 3 in Switzerland. 1 in Austria. 3 in the Netherlands. And Raymond, it's 0.
It depends. I mean, I think it depends on the seniority of the role. So 1 month for something junior, 3 months for something senior is normal in the UK.
Okay. And Reinier, you seem to be a little bit undecided how many months.
I was heavily shaking my head at 3 months, because it was 1 or 2. And that's dependent on the duration of the contract. So with a fixed term contract, it depends. You can have a 1-year contract with a 1-month probationary period, for example. Below 6 months contracts, you can't have a probationary period at all. And the maximum from 1-year contracts and up is 2 months of a probationary period. So okay. It's rather regulated. And that's particularly a clause that you must agree to in the employment agreement. Otherwise, the clause doesn't exist, obviously.
So I think the only one who doesn't accept any trial period at all was Ludo in Belgium, right?
Yes, that's right. We abolished this possibility about 6 years ago. But in the first period of employment, the notice periods are very short. It starts with 1 week, and then it goes up after 3 months to 2 weeks, etc. So it came instead of probationary period. So in the first, let's say about a year, periods of notice are very short.
Okay, so the approach might be different, but in any of these countries, you have the possibility, if you have an employee, to either test him at least for a month in Austria, or be able to lay him off with quite a short notice period. So the risks that you are taking as an employer are quite limited and should not prevent you from hiring in that country. After talking about a trial period, can I set in your jurisdiction a fixed term for the employment contract? Yes, in Belgium, Spain, Austria, Switzerland, France. Well, in all the countries, it's possible. if we talk about a fixed term, the question is quite often what happens at the end of such term. Uwe, could you explain maybe for France what happens when it comes to the end term and what options I have as the employer?
When it comes to the end, the contract will end, and normally the relationship is over, except the employee continues with your agreement to work for the company, and then it will become an unlimited time contract.
Okay, so it's perfect if I have a certain mission for somebody to fulfill, and I know that from the start it's going to take at the most a certain period of time. So I will not need this employee later on.
Yeah, the problem in France is that every limited contract for a certain time has to be justified by a reason. So you need there is no such thing like in Germany, when you can for the first 2 years you can hire someone on a limited basis, time limit basis. In France, there has to be a reason, and those reasons are quite limited. So for example, you cannot hire someone for an activity which is the normal activity of the company. It should be something outside of the normal activity, or to replace a sick person, this kind of thing. But it's very limited, although in practice it's used quite often.
Okay, so we already get the answer for Germany as well. I would like to pass the question to the others. Do you need a reason to have a fixed term for the labor law contract? Wow, that is liberal. So France and Spain are the only ones that are asking for a reasoning. José, is there any limitation to the reasons that I can use to limit such a contract?
Yeah, yes. In fact, the law in Spain is quite restrictive regarding this matter. You need a ground to make a temporary contract. Very much in the sense that Uwe told us for France, you need to be a substitute, a temporary substitute for a non-time limited employee, for illness, for example, or maternity, or you need to be in a special task for the company with a temporary nature. You can't be hired for a common work of the company with a temporary contract. And the government here is thinking to make even harder, because theoretically there is a limitation, but the fact is that temporary contracts are widely used in Spain, and they are trying to reduce this practice.
And why are they so widely used? What are the employers afraid of if they have an open-end contract?
Yeah, in Spain, the termination of the relationship is very related with severance payment. In general terms, you can terminate a relationship, but you need to pay a severance payment. In a temporary contract, even in some temporary contracts, there is also severance, but it's much more reduced. It's cheaper to terminate a time-limited contract than a non-time limited contract. This is the reason.
Okay, and can I have one limited contract one after another? So until retirement age, give an employee only limited contracts?
No. Every time limited contract has a maximum. It depends on the nature of the temporary situation, but in general terms, you can't have more than 3 years of a temporary contract in Spain.
Okay. We have a question, and I would like to give it to the panel. You don't have to answer it right now, but maybe you can think about it. One of our spectators asks, what does it take to create a more European tech-friendly labor market that allows for true pan-European job mobility? So think about it, and maybe you come up with 2 or 3 suggestions that we can forward to the European Commission, and we can solve the problem right away. The next question that I have to you is, do you have, as an employer in your country, to apply a collective bargaining agreement if such exists? Well, the answer seems to be yes everywhere. Raymond, was that a yes? No, it's a no, and it's a no in Germany. That is surprising. I thought the unions were strong, and the bargaining between unions and employers is the basis of the good understanding in the German law market.
Well, there is no legal obligation to apply a collective bargaining agreement unless the employer is part of the employers association and the association has negotiated a collective bargaining agreement. Then you have to apply it, but there is no need to join the employers association. It's your free choice, and if you don't, and currently more and more employers don't, if you don't join, then you don't have to apply the collective bargaining agreement. There are very, very limited exceptions to that rule when the Federal Ministry of Labor and Social Security decides that one collective bargaining agreement applies to all the employment relationships in a particular area. For example, construction would be one of those areas. But apart from that, and for most employment relationships, there is no obligation to join a collective bargaining agreement.
When we come to the tech industry, would you say that lots of employees are unionized in that area, or
no,
so
no.
they are not expecting to come to a company that has such a bargaining agreement?
No, in most cases not, and especially when it comes to senior positions, usually they are not bound by collective bargaining agreements.
Okay. In your jurisdiction, do you have a minimum wage? Well, even in the UK, and Austria and Switzerland are the only countries that don't have a minimum wage. But Roy, if I come to you first, I have the impression always when I come to Switzerland that everybody needs to earn at least twice what I earn to be able to pay for the coffee and the sandwich at the bakery, because otherwise I don't know how they make ends meet.
Yes, and you're right. Cost of living is high, and therefore also the salaries are probably a bit higher. But you know, at the end of the month, it's nothing is left anymore usually, so that is quite a problem. But there is no minimum wage. I mean, basically, you could, you know, potentially agree with an employee to pay him just, you know, a few Swiss francs a month, and that would be perfectly valid and legal. Would be nothing wrong with that.
Okay, but you don't find anybody for that job then?
You know, I have a client that did exactly that actually, and he did agree to an employment contract where he was paid very little money, and I offered him a job right away in our firm. It's a true story.
Karoline, in Austria, how can that work if you don't have a minimum wage? Don't you have a class of people who are earning less than the unemployed, and therefore lots of social unrest due to that?
Not exactly. No, we don't have a specific nationwide or statewide minimum wage, but we do have a very detailed branch system in the CLA systems, collective bargaining agreements, which apply to the branches, and they do have minimum wages, but it's not one minimum wage for everyone. So.
Okay, but due to the bargaining agreements, you have de facto in what would you say, 80% of the labor market de facto minimum wage?
I would go as far as 98%. So
Okay, well,
yeah.
That's another example that you, without calling it a minimum wage, you can have exact the same effect in Switzerland by raising the prices for coffee, and in Austria by having bargaining agreements. I think that is important for the companies that go abroad to say, well, even if the systems look different, quite often they try to obtain the same goal. So don't have the impression that just because you read on the internet that there's no minimum wage in Austria, that you might make a bargain there, because in the end you have to pay the same standards that you might pay in other European countries. My next question would be what are the minimum benefits that I have to provide in your jurisdiction? And maybe I could start this time with Reinier in the Netherlands. Is there something that I have to give apart from, of course, a correct salary to my employee?
Well, yeah, we have a minimum wage. That's where it starts, and there are also some other benefits, such as the minimum.
What is the minimum wage at the moment in the Netherlands?
Minimum wage is just above 1,700 euros a month gross.
And that means for how many hours of work?
That's a full-time job.
And what is a full-time job?
Full-time job is
20 hours probably.
Normally it's 40 hours. That's 40 hours a week is the standard, but it depends also on collective bargaining agreements that may define that it's 36 hours or 38 hours. And that depends on also from employer to employer, what is a normal working week. So there's also a minimum hourly wage that you need to pay to make sure that you can't play with hours in that respect. But that's the minimum wage. Other things you can think of is pension. In many collective bargaining agreements, it is mandatory to provide pension, but there's no general rule that says that you should pay pension, but it's very customary, of course.
Yeah, you don't need to pay pension. Are there any other pension? Are there any other countries where for an employee you do not need to pay mandatory contributions to a pension system?
Only state pension we have always, so that's important differentiation. But our pension schemes or pension funds are not mandatory, except for in collective bargaining.
But you would still say that it might be, depending on the industry, a standard that in addition you pay into a private pension fund, or you provide it directly by your company if it's a big group.
Absolutely, and it's of course a very customary benefit. So if you want to provide attractive benefits, then it's certainly something to consider.
Is there any jurisdiction where you don't have to provide health insurance to your employee? No. In Switzerland, you don't need to give health insurance because it's so healthy anyway. Nobody feels sick. Right. How can you explain that? You, as an employee, you have to pay it by yourself in addition for the expensive coffee.
Exactly. That's why the salaries are higher, because you need to pay yourself for your health insurance.
Okay, that can be an interesting point when you discuss with a future, with a candidate for your employee, that when you talk about a salary in some countries, you might talk about the full sum that you are finally paying as a company. In some countries, like in France, if we're talking about a salary, normally in a discussion with a candidate, Uwe, what would you say is the candidate understanding, the net that he gets after paying contributions to social security, taxes, and everything, or which part in between might he focus on when he's talking about a number?
Normally, he will ask for gross up salary, so gross salary. He will, and then of course he has to calculate, considering that he will have to pay between 20 and 25% of the gross salary for social contributions on his side, and then there will be, of course, the tax on the revenue he has to pay, which is also deducted by the employer and paid to the state directly. But normally you will talk about gross salary, and then there are some additional benefits. In France, of course, you have to the employee has to pay for the social security. This includes already healthcare, but the employers are obliged to provide the employees with the possibility to have additional healthcare. This is one of the benefits there.
Okay, and Reinier, in the Netherlands, you don't have to provide a healthcare scheme. Is this still best practice and expected by most of the employees?
No, it's not so common, and I think that in the Netherlands also healthcare premiums are not that high to take out a health insurance policy, so it's not really an issue.
So we're talking about private health insurance.
Yeah.
You do not have any state regulated or state offered health insurance program.
Well, it's mandatory in the Netherlands to take out a health insurance policy, but that's something you do on an individual private basis. And it is not very attractive to pay that as an employer. So because it's not attractive from a tax perspective, it is also not part of the usual benefits in the Netherlands.
Okay. Raymond, in the UK, you still have the NHS system, right?
We still do, yeah, exactly. The much loved NHS system. But I have to say that private medical health benefit is a very popular benefit in the UK. And you tend to find it particularly with more senior employees, but it is a benefit that people really like to try and get their hands on if they can, despite the NHS. So I think, yeah.
One question is, when we were talking about retirement funding, in addition to that, there might be some retirement benefits that you have to pay as an employer at the age of retirement of your employee. Does that exist in your jurisdiction? I mean, a sort of a golden handshake when he leaves the company. You see that is only the case in France and Germany. In Germany, how much do you pay? 50 euros, generously?
Well, it depends. It depends. So what you have to pay is, in fact, round about 50 euros. I think it's 42 that the employee can require you to pay additionally to the remuneration. But you have to keep in mind that we have statutory insurance, pension insurance, so which is quite high actually. It's around about 20% of the gross salary. So most employees actually are covered by that. Historically, there has been a lot of pension funds that have been covered by the employees, but that is declining for economic reasons, because you don't really get any profit from that anymore, and the guarantees that you have to give your employee are quite high. So most employers have to pay something on top to fulfill the statutory requirements, and so they don't do it anymore. There's a small percentage that you have to pay.
But you do not have to pay out of your pocket at the moment when they retire an extra bonus.
No, sorry, no, that's not the case. But during the employment relationship, the employee can demand a very small amount
contribution
to a private pension fund.
Because if I'm not mistaken, Uwe, that is a specialty in France, right?
Yes, yes, we don't have the system of the company pensions or those benefits, but almost in every case when the employee leaves the company, you have to pay severance, like José told us already. In France, it's very similar. And when you dismiss someone, you have, of course, a severance, except when it's for gross disciplinary reasons. And also when the person retires, either on your behalf or because he's wanted to leave to go to retirement, then you have to pay some severance, which is normally foreseen by the collective bargaining agreements. In France, it's a little bit like in Austria. So we have collective bargaining agreements for almost every branch of activity you can imagine. And they are all extended by state decisions. So every employer has to apply them.
Okay, my next question would be, can you agree to a performance-based compensation in your jurisdiction? Well, that's at least one good answer. It's a yes everywhere. So probably when it comes to the details, it gets a little bit more complicated. Maybe we can come to it later on. But the good thing to know is that performance is still something that you can consider when you hire somebody. The next question is, can you give a stock option program or something similar to your employee? Well, again, only yes. Does somebody have heard the term virtual shares in your jurisdiction? Okay, so Ludo, maybe can you tell us what do you understand by virtual options or virtual shares when it comes to a labor?
We have a very complicated system that allows smaller companies that are not registered on the stock market to introduce a kind of a stock option plan, which is not related to the own actions of the company, but to officially registered schemes. So it's a very complicated system, and it's not very often used by companies because it is far too complicated. So in Belgium, you can better give your employee a company car. He will ask for a company car and meal vouchers. Meal vouchers. That's very popular in Belgium. A company car and meal vouchers.
What was the second? A voucher for?
Meal vouchers.
Oh, okay. And what is the amount of the meal voucher that I can give?
It has a maximum of €8 a day.
Okay, and that voucher can be given electronically, or do you still have like a sort of second paper money?
It must be given electronically. And in supermarkets here in Belgium, you will see very often, every day, every client will pay with this electronic meal vouchers. It has everything to do with taxes. Our wages are heavily taxed, so it's kind of an escape route along with company cars. An escape route out of the very heavy taxes.
Okay, so in Belgium, you should always think about meal vouchers and company cars. Is there any other country where company cars are of importance? UK, no. I thought you're still producing. Well, Germany is obvious, so we don't have to talk about that. Let's go to Austria. Austria, why is it important in Austria? You have such a good infrastructure. Why should people need to have a company car?
Yeah, well, actually, there are two options. You can offer a company car, which is, of course, a big status symbol, and which usually like traveling employees get from their employer or higher up employees. But you can also offer a tax-friendly ticket for the tram and the metro and stuff. So this is also an option.
And if we talk about tax friendly, can I give a Ferrari to my employee and deduct it fully, or are there any caps, any limits, or does he have to take 50% of the value of the company as an additional taxable benefit?
Well, that depends on what kind of tax you mean, but only usually in the labor context, you have to, or the employee has to pay a tax for private use of the company car. But otherwise, from a labor law perspective, there are no taxes. But of course, like company taxes and luxury caps, there are, of course, those as well.
Benjamin, are there any luxury caps in Germany?
Yes, indeed, they are. So tax authority will look at from the company side. We'll look at whether this car is adequate or not. From the employee side, it's just a standard 1% tax a month. So this is the advantage that you receive from the employer. It's 1% of the sales price of the car, and you have to tax that every month.
So if I buy for my employee an old Mercedes for 5,000 euros, a Class S that I found cheaply on the market, he only has to pay 1% a month of that 5,000 euros price?
Actually, it's the original sales price, so the retail price. But there are some exceptions when the car is extremely old and is not really worthy anymore. But most company cars are new cars actually, and they are leased for 3 to 5 years, and then they're sold on the private market.
Okay, that might be an explanation why we see on Autobahn always only new cars. I would like to ask our spectators to participate in a small poll. It's only one question, it's very fast, but it could give us some insight on which countries you are most interested in, because you might be planning of hiring there. So please answer the poll. It's anonymous, so nobody will know that you are thinking about hiring there. And that might give us a chance in the second part of the 30 minutes question and answers to go into more detail with one of the countries where most spectators are interested in. I have a very, very practical question, and that is, who takes care of the payslip? And I don't mean it's the employer. Of course, it's the employer. It's not the employer that's providing it. But in your jurisdiction, is there an easily accessible service provider that will help people with providing payslips to the employees? Well, there should be a no somewhere. It's a no in Switzerland. In Switzerland, it's so easy that you can do it. Could you do it? Well, if you were not a lawyer, would your colleagues from construction law be able to hand out and prepare the pay slips for all your employees in your law firm? Or do you need to do that because you have a background as a labor law lawyer?
No, you don't even need to be a lawyer to be able to do that. I mean, it's pretty simple, it's pretty straightforward. So you wouldn't need an external provider to do that for you.
Well, that means how many lines do I have on that pay slip? How many different percentages that are taken away, sometimes from the employee, sometimes from the employer, some are added later on for tax purposes, some are not. That is.
No, there are some deductions for social insurances, which are around, I would say, 4 or 5 lines, if you wish. but these are, you know, standard percentages that are being deducted. So there, you won't need to have a master to be able to do that.
Wow. Uwe, do you think that you would be able to do that for the employees of our law firm?
No, no, clearly no. It's too complicated. We have lots of questions about it, especially when people are leaving companies and you're agreeing about the settlement and some payments you will make. And there are lots of questions, and there are lots of lines on those things, and you have to deduct the taxes as an employer. So you need, in France, you need someone, a service provider. Quite often these tax consultants, they're doing it. It costs you between 20 and 40 euros a month per payslip.
Okay, Reinier, is it complicated in the Netherlands, or would you be able to do it by your own?
Me, certainly not, but I think that with some advice and a good software product, you probably can get by. But most of my clients would definitely ask a service provider to take care of everything, in particular when the benefits are a bit more complex.
Okay. Does anybody would pay less than 20 euros to a service provider per payslip per month? Just if you have that. That is more complicated in Belgium than I would have thought, but no, 20 seems to be the best bet. Okay. Quite an interesting question is withholding wage tax. In your jurisdiction, does the employer need to withhold the wage tax, which is also called like taxing at the source? So the yes, nearly everywhere in Spain, it's a yes too, but not in Switzerland. Why not? Do you trust people?
Indeed, we do actually. We also give all the men a weapon, you know, when they enter the military service, so they can keep their weapons at home. We actually do trust that this is, you know, enshrined in our DNA, if you like. So you only deduct tax at source for non-Swiss nationals, but all Swiss nationals do not have to deduct the taxes at source.
Okay. Taxation at the source might be a little bit complicated because I need to know a lot of information about my employee, maybe how many kids he has, if he's married or not. In some countries, they might even ask a question about the religion, Benjamin.
Yes, indeed. We have a very curious system of state-church relationships. And to this day, some churches, bigger ones, are still allowed to levy taxes. So the tax authority would deduct the taxes from the employees and would then give it over to the churches. So employers, in fact, have to know their employees' religion to properly deduct the taxes for them.
This is a matter of interest. How can I get out of the club and avoiding paying taxes to a club I might not want to join anymore? Is that possible?
Yes, it is possible, but you have to go to the local court, actually. So you can join a church just by going there and saying, I want to be a member, but you can only leave when going to the local court. And right now we have a bit of a scandal going on in the Catholic Church. Very, very unfortunate things have happened with regards to children in the past, and many people want to leave the Catholic Church. But in Cologne, for example, you have to wait, I think, 3 months until you get an appointment at the local court. So you can't leave earlier than that.
Interesting. Is there any jurisdiction where, as an employer, you are forbidden from asking questions about the personal situation? And therefore you might be in a difficult situation to know how much wage tax you have to withhold. Is that an issue somewhere? No? That should be. I could see from my friends from personal data protection, that there could be issues, especially if you keep these informations available to third parties like accounting. But that might be an issue for another webinar. We come to a very practical question. It's how many working hours can you agree to with your employee? Well, that is difficult. Maybe with one hand you show the first number and with the other one the second. I see it's 40, 45? No, it's 43. 43 in Spain. Well, the difficulty is how do I read it? Well, maybe go from one to the other. Ludo, what is the maximum hour? Are there any maximum hours?
The average hours a week are 38 in Belgium, but you can organize a working scheme of 40 hours a week, but then you have to give employees 12 days off every year on top of their annual holidays. So and you can modulate. You could, for instance, employ someone for 39 hours a week and then give them 6 days off a year to compensate. So at the end, by the end of the year, you end with 38 hours a week on average.
Okay, José, how does it work in Spain?
In Spain, the general rule is 40 hours per week, but you have also the CBAs. The CBAs normally state what is the maximum hours per year, and normally they are a little bit less than 40 hours per week. You can work 40 hours per week, but you need to grant some extra holidays to fit the yearly cap stated in the CBAs.
Okay. Karoline, in Austria, is there a limit?
Yeah, so we have the legal working time, which is 40 hours per week. And then in the different CBAs, they are regulated differently, but overall, it's most of the time 38.5 hours per week. And then, of course, but I think this is EU-wide, the maximum cap of 60 hours per week. And on average, it's 48 per 17 weeks. So, yeah.
Right, I'm sure that you're going to surprise us by saying that you can work as long as you want to.
I wish, no, it's not that simple, but the average is something between 40 and 42 hours, and the maximum is 45 hours.
Okay, so it's a clear cap, no sliding, no account of hours that you can work for a certain time, and then you have to give a leave. You have an average.
There is a maximum of 45 hours per week, but the employees can work longer. You just need to compensate them.
Okay, so there's no, I have to pay overtime extra,
Yes.
but I can work, have them work 200 hours a week.
Pretty much, yes.
Okay. Uwe, how does it work in France?
As you know, the mandatory working time, or the statutory working time in France is 35 hours a week, and then we have similar systems like in Belgium. Of course, the people can work more, but then they have to get additional rest days in order to have, again, those 35 hours a week. But depending on the collective bargaining agreements, there are other possibilities depending on the status of the employee. When he's a manager, he can, for example, work at a flat rate in days for a year. This is limited to 280 days a year, and then you will not look at how many hours he's working a day, but he will also get additional rest days. But again, the statutory working time is 35 hours a week.
Okay, Reinier, the Netherlands, 25 hours.
I think 40 is quite customary, and in some companies it's 38 or 36, some often defined by collective bargaining agreement. The maximum per week is 60, but you can't work all weeks 60 hours. So the maximum average is 55 per 4 weeks. So that's how it's arranged. And the Working Hours Conditions Act doesn't apply to all workers. So above a certain salary cap, nobody bothers.
Okay. Raymond, are there any restrictions at all in the UK?
Well, there are. So it's an average of 48 hours a week, and there is a different rule for young workers. But there's also something called the opt-out. So an employee can agree to opt out of having a limit on their working time, and they can then opt back in. But the opt-out is really designed for the sorts of employees that make their own hours. So sort of CEOs, particularly senior executives who come and go as they please, if you like. So it's a slightly hybrid kind of system. But it's not unusual to see an opt-out agreement with an employment contract in the UK.
Okay. And for the opt-out, I have to pay an extra compensation to make it valid? Or?
No, not at all, not at all. And because it tends to be highly paid executives, it's seen as part of the job, if you like, that you get the big bucks, but in return you're expected to, give your life or most of it to working with the business, with the organization. Okay. Yeah.
Benjamin, in Germany.
Well, standard practice is something between 37, 40 hours a week. Legally, you can work permanently 48 hours a week, but you have to spread it out on 6 days. So you would work from Monday to Saturday. If you work more than that, maximum of 60 hours, then you have to be compensated by additional free time. Over a certain period, depends on the profession you're in. Sometimes it's 12 weeks, sometimes it's 17. But that's roundabout the standard. But you cannot opt out of it. So in Germany, you might even be fined if you let your employees work for too long. And this is true. There have even been searches in the offices of law firms because they tend to work longer than that. And sometimes they have been fined in the past.
Okay. Well, we have gone through the questions that I prepared for our webinar. But in the meantime, we got some additional questions from our public. And I would also emphasize that they are most interested in France, the Netherlands, and Switzerland. The reason might be that they show some characters that then are representative for groups of countries in Europe. And I think that is already a good thing if we have given a certain way of regrouping the countries so that somebody, even though he's not familiar with all the details of the legal system, might understand that the approach in 2 or 3 European countries is similar, whereas in some other countries they come from the opposite direction. And one of the question is, do I have to pay for overtime? And I would bet that there's no. No, Raymond, you don't have to pay for overtime. You can work until you die. That's the spirit.
It's a matter for negotiation, as are a lot of things in the UK, that the idea is freedom to contract, which is a bit artificial, but it is a matter of negotiation. It's not a right. Yeah.
Okay. And another question was, how much paid vacation must I grant? And maybe if we talk about weeks, that might be the easiest one. Probably nobody will need both hands. Oh, that looks like less than 5 in all the countries. Uwe, you're not showing any hands. There are no vacations in France.
25 days or 30 working days. It depends how you count it. If you count Monday through Saturday, then it will be 30 days. But if you are counting just Monday through Friday, then it's 25.
25, so we're talking about 5 weeks. Okay.
Yes.
And when we come to, because some countries might have a rule which says that in the first year when you work, you cannot take out any vacation because you have to earn it first. Uwe, is that an issue in France?
Yeah, this is a very strange system. Normally, for the first year, or there are some, it's called the reference period, which starts on the 1st of June and will go to the 31st of May, the next year. And this year you will get, so you will earn some paid vacation rights, and then you can take them in the following reference period. But they changed the law a few years back, and now you can start taking vacation at the beginning of your employment if you want to, but the counting will still be as I told you. So you will get the right in the first reference period, and then you can take it in the next one. This has as a consequence that quite always when an employee is leaving the company, you have to pay him an indemnity for non-taken paid vacation rights.
Okay. Is there any other jurisdiction where you have that sort of a little bit weird system? Because I do not understand that it protects the employee if he has to work a year before he can take the first vacation. Oh, José, that is
no, in
smallness.
Spain, in Spain you are entitled to a legal minimum of 30 days per year, and you are allowed to take it from the beginning. You don't need to wait 1 year.
But I need the agreement of the employer, or can I say I just signed on and 1 month later I say I want to go on vacation for 6 weeks?
Okay, you are entitled, but you need to agree with the employer. If there is no agreement, you need to go to the court. But if for the company is organizational, is not an organizational problem, they need to grant you. If the relationship ends earlier, probably the employee needs to return some money for the extra holidays he or she took, but you are entitled to have your holidays.
Okay. One question from the public is, on a scale from 0 to 10, how tech-friendly would you rate your national ecosystem? Just a 4 in Germany. That is surprising. Well, France is even less. So Austria, Switzerland. Roy, why would you consider your country tech-friendly?
It's a difficult question because it's been a very general question. But I know, a bit about the startup industry in Switzerland, and it's very big. And a lot of startups are actually coming to Switzerland to start their businesses here, which gives me the impression that it must be, a good sort of place where you want to establish your enterprise.
Karoline, why would you say that Austria is a tech-friendly ecosystem?
Well, especially if you want to establish a company here, it's and you're not an EU citizen or owner, then it's even easier if you have a tech background or tech company to establish your business here and get a residency permit. So that's one of the points.
Okay, and Reinier, I think you also said that you consider the Netherlands as tech-friendly.
Yeah, absolutely. Although I think we can do better on some ends, but the Netherlands does try to create an ecosystem that's very tech-friendly, in particular aimed for innovative companies. Also through some subsidies on R&D and yeah, to create ecosystems where tech companies can thrive. And just as Karoline said, there are some specific schemes for immigration, because I think that the tech companies highly depend on also international staff and on mobility often. Problem with that is often that these tech companies can also be startups, and startups have little history to show for often, and therefore it can be a bit of a rough start.
One of the questions from our public lead, of course, to the bad aspect that you might have when hiring somebody, that it was not the perfect fit and that you have to fire that person. So I would like to talk a little bit about the firing process in each jurisdiction. Maybe first sort out the jurisdiction where it's no problem, where you can do hire and fire. Is there any country where you can just fire somebody without having to justify your reasons? Switzerland? UK? Okay, so Roy, in Switzerland, I can fire my employee from one day to another, and I don't have to explain to him why.
This is one of the particularities of the Swiss labor law, is that it's quite employer friendly, you know, compared to the other most of the other countries in the EU. So yes, as long as you give notice and you don't violate the notice period, you can give notice more or less at any time. At first, without having to give any reasons for the termination. If the employee asks for the reasons, then you need to provide them.
Okay, then maybe we come to the second group. Would you say that you are in a jurisdiction where you can fire somebody and it's only a question of money? We have yes in Belgium, France, and Austria. So let's go to the remaining group. José, why is it not a matter of money only?
Okay, it depends on the circumstance. Normally, it's just a matter of money. You can pay the severance and that's all. But there are some quite common circumstances that can, in practice, deny this possibility. For example, if you dismiss someone who is entitled to join some right related with paternity or maternity, the dismissal would be automatically null and void, and you will be forced to readmit the employee. Or if you dismiss someone related with the Works Council, for example, but is much more common, people who is taking the schedule reduction for childcare, very common in Spain. If you have children with less than 12 years old, you are entitled to ask for a schedule reduction. And as far as you have this schedule reduction, you can't be fired. Of course, if there is a relevant disciplinary ground, yes, but you can't be fired, and the dismissal would be considered null and void.
Okay, Benjamin, would you say that describes the situation in Germany as well?
No, not really, because our starting point is different. So in Germany, the question only is, does the employment relationship still exist or not? In a way, the protection against unfair dismissal is a bit dishonest, because that is the statutory starting point. So either you are employed or you are not. Either the termination is valid or it's void. And as an employer, you almost always need some sort of reason for dismissal. Only in the first 6 months, you don't need that, which is why the trial period is so important in Germany. And after that, if you have a business that's a bit bigger, more than 10 employees, you will have to have some reason. In practice, many employment-related disputes are settled by a severance payment, but there is no legal obligation to do so. And especially in the cases where the employer would like to get rid of an employee by just paying some money, the employee can just say, no, I won't go back to work. And this is really painful sometimes for the employers.
Then would you find the Netherlands in one of the descriptions of Spain or Germany, or do you have a completely different situation?
I would say it's pretty different. To start, yes, most terminations are settlements, and yes, money does solve a lot of termination problems. So if you have big pockets and you want to spend it on termination, then go ahead. It probably works. But the Dutch termination system is called a closed termination system, which means that you need to have a ground for the termination. And if you have a ground, and the ground itself determines how the process will go. We have a preemptive check on terminations, meaning that if the employee doesn't want to cooperate, a notice can only be served after a permission has been obtained from the authorities, from the employment agency. So that requires a full application process, which can take quite some months before a notice can be served for example, business economic grounds. For all more personally related grounds like underperformance or culpable behavior, you would have to present a case before the cantonal court. And that's the only way to end the employment relationship, apart from, of course, summary dismissals, which can take place in cases of very gross misconduct, for example. So yes, we stand out with a preemptive check.
Okay. One of my last questions would be, from your experience, your years-long experience, what would you say is the most common mistake that a foreign employer can make in your jurisdiction? And I would like to start with Ludo, Belgium.
There are very many mistakes you can make in Belgium because the legislation is so complicated and has different layers. We have not only federal legislation, we have also the Flemish, the Dutch speaking, in the Dutch speaking part of the country, another layer of legislation, and then you have the collective labor agreements, etc. So there are mistakes at around every corner. But I think the biggest mistake would be to start without proper advice, and that would be the best advice I could give.
Right. In a country like Switzerland, that might be a walk in the park for the employer, right? There are no mistakes that you can do.
You can. I wouldn't say these are mistakes that you cannot solve by paying maybe a bit more salary or some compensation. But of course you can make mistakes, and therefore it is very advisable to get consulting before entering and before agreeing on any employment contracts.
Raymond, what is, from your experience, the biggest mistake new foreign employees can make in the UK?
So I've seen it with companies coming in from Europe and also companies coming in from the US that have been fantastically successful in their home jurisdictions, and they believe that they can continue to conduct themselves and to treat their employees in the UK as they have in the countries where they've started or where they've worked in. So to echo Ludo's point, really, I think the starting point is to do your due diligence before you start having employees in any of our jurisdictions, to understand the systems that work, and not to have preconceptions. So some people from Europe, you know, think in the UK is almost like a US system of very little controls on the day-to-day employment rules, unless you're talking about discrimination, and that's not true. And other people think that we're quite prescriptive, like some European countries are, in terms of there's an answer to every situation. It's very codified. And the UK is a hybrid. There's a lot of black letter law, but also there's a lot of concepts around reasonableness and concepts which are very alien to people that haven't operated here before. So I think you have to do your due diligence and understand how it works locally before you start engaging or employing people and putting boots on the ground.
In the beginning, one of the spectators asked the questions, if you, from your experience, have any good idea or any suggestion how the European legislator or the national parliaments could improve mobility throughout Europe. I gave you enough time. I think 30 minutes, you should be able to come up with the great idea that helps us all bring the European labor market together. Does anyone have a suggestion to that? Well, I see Karoline. Karoline?
Yeah, well, from our experience, and especially nowadays and during the COVID crisis, when a lot of people are working from home or working from abroad, we found that the social insurance system is kind of difficult to understand and to maneuver between the different legislations. So there might be an angle to maybe make this easier, maybe make it by choice. But this is just our experience, or just an idea.
See that Jean-Christophe is coming back, which means we are coming close to the end of our webinar. Jean-Christophe, did you have any question in your mind when you heard all these explanations, or are you more confused than when you entered this webinar?
Well, I wouldn't say that I'm more confused. I think I'm reassured to know that with all these wonderful legal experts that covered in 60 minutes as much as you wouldn't be able to read on your own. I mean, we covered health insurance practices, average work time per week, retirement benefits, company cars, severance payments, termination systems, performance-based things like stock options, which are super important for tech entrepreneurs. And if you send somebody to another country for a capture a new market, I mean, these are the realities we are facing with these hyper-growth companies. What about the obligations to formalize a contract, a work contract? I mean, things that should be walk-around knowledge, but are not treated in the same way at all in Europe. So yeah, I think it's a challenge, but at the same time, it's amazing to see that diversity. Just looking at the selection of 8 countries, which happen to be now also in the final rounds of the European Championship.
Still, that might change in the next week.
So yeah, maybe there's an analogy there, between the European Championship and the European Champions Alliance. Definitely, when we chose the name, we didn't play with this because we were really serious. We need more European champions. The economic welfare and social fabric in Europe depends on our ability to innovate, to step up, and definitely the legal enabling framework is absolutely crucial because it needs to be enabling and not slowing this down. And this is a big competitive issue, I believe, for us in Europe. We have a very high, social protection net, and it works well, very well. it's probably one of the best working systems as you compare it to other markets. But is it also enabling us to accompany the hypergrowth companies to work? These are, I think, the challenges we need to reflect, and I think that's the key message here. The European Champions Alliance is out there, and we're very happy to have had you share your legal expertise to help bring a bit, shed a bit of transparency in this a bit confusing system if you navigate between these different, very fragmented, from a legal standpoint, ecosystems, because a company wants to grow in Europe. And yes, there are different language issues and challenges, but on top of that, you have to deal with so many different national legal systems. And it's simply reminding me of an old Latin adage, vigilantibus non dormientibus jura sum veniunt. So the law only helps those that are woken up, and not for those who are sleeping. So it's very true here again. Thank you so much for having shared all these insights, and I would say that we give ourselves a rendezvous for the 30th of September for the next round.
Right. The next round is on Thursday, again, probably at 5 o'clock, but please look it up on the 30th of September. And the subject of this webinar will be corporate law. We will have other webinars about IP law, about tax law. So there are lots of things in the pipeline that will probably interest a lot of tech companies here in Europe.
And should you have a topic that is dear to you, don't hesitate to write to welcome@europeanchampions.org, and we'll be happy to suggest it to for a next round of a masterclass. For now, I wish you a very good summer. First, a successful European Championship, then a successful summer, and please stay safe. Thank you very much for having been with us.